What I can tell you is I'm not going to grant your application for deferred adjudication because you're here as a felon in possession of a weapon, which means you should know that you shouldn't possess a weapon. So I am going to find you guilty, but I'm going to grant your application for community supervision. All right, the court is calling 2025 CR 010507 State versus James Alexander Oiedo. Could I have parties announced?
Trey Maurer for defendant.
All right, and are you Mr., how do you pronounce your last name?
Oviedo.
Oviedo.
Oviedo. There you go.
Thank you. Are you Mr. Oviedo?
Yes, ma'am.
Counsel, have you received all discovery? Did you review with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Sir, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, sir.
Sir, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with unlawful possession of a firearm by a felon as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, or re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's a $1,400 fine and the state is silent on your application. Did you understand that to be the plea? Defense?
Yes, Your Honor, that is correct. Additionally, this case is being handled by CTD. He has another case that is being handled by family violence that is supposed to be taken into consideration as part of this plea.
All right. What is the state?
But I was gonna tender to this before the day of his PSI.
Okay. So is that a part of the plea bargain agreement?
Yeah, I believe so, Your Honor.
All right, should it be in here?
Yes, that's why.
Okay.
I give you the case number, Your Honor.
Yes, so taken in consideration,
2025
Hmm.
CR 011223.
all right, and also taken in consideration 2025 CR 011223. Is that the plea?
It is, Your Honor.
Is that the
Yes.
plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand
Yes.
any such motion?
No, Your Honor.
Outside the agreement, the state is saying that you are to have no contact with witness Carazelis. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No. Comment.
State any evidence.
Yes, Your Honor. Pick up the seat.
No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court would defer finding of guilt as you applied for deferred adjudication. So family violence,
Yes, Your Honor.
you're taking this into consideration? The 2025 case?
Yes, Your Honor.
And have you all spoken to the complainant? Because I'm trying to make a decision on whether or not to proceed with sentencing today or not.
We've attempted.
Okay. All right, do you wish to proceed with sentencing, counsel?
No, Your Honor, we will request a PSI.
Do you wish to proceed with sentencing?
We would request a PSI, Your Honor, unless the court is going to grant our application, then
Well, do you wish to proceed with sentencing? Either you want to proceed with sentencing now or you want a PSI.
we would request a PSI, Your Honor. Okay, then we will proceed with
No,
that.
I mean, it's completely up to you. You want to discuss it with your client? All right. So anything you wish to say on behalf of your client?
No, Your Honor. Obviously, Mr. Oviedo is, he's disabled. He's not working right now. We just asked the court to grant his application so he can continue trying to do better with his life and to put this situation behind him so he can move on.
All right, so, sir, you're receiving SSI?
Disability.
All right. And are you still in contact with the person that the state is asking for no contact?
No, ma'am.
Is that relationship over?
Yes, ma'am.
All right, and I'll note that in the police report, it said when this happened, he was in a wheelchair. And it appears from reading the police report that there was an altercation involving him and the person who was shot. And it appears that the shooting was an accident. Potentially, that's what's in the police. I'm just going by the stipulations that have been given to me. That's what's in the police report. The reactions at the shooting could have been a little bit better, but that's what the court is going on. What I can tell you is I'm not going to grant your application for deferred adjudication because you're here as a felon in possession of a weapon, which means you should know that you shouldn't possess a weapon. So I am going to find you guilty, but I'm going to grant your application for community supervision. All right, court will find you guilty, sentence you to 6 years in the prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person, regular random UAs. There's a $1,400 fine that will be probated. Field visits 1 time per month until further notice. Take in consideration 2025 CR 011223. There's to be no contact with. There's to be 100 hours community service restitution. I'm going to order the MRT. Once the MRT is completed, then 50 of those hours will be deemed satisfied. The remaining 50 hours will be deemed satisfied upon completion of anger management. And there's to be no possessing of any weapons. Do you understand? Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
Oh, Your Honor, he is on an ankle monitor right now. Will that be removed once he begins his community supervision?
That's going to remain on probation. We'll keep the ankle monitor on for 3 months, at least until he's started the services.
Yes.
Okay. And that will be tracking only and waive fees. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And I'm so sorry, add destruction of the weapon. All right, because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what that is, you'll need to speak to an attorney. Do you understand? All right, good. Yes.
With the pretrial services and I start the probation, would I still have to contact her to leave?
No, you'll be under the umbrella of probation.
Okay.
All right, Thank you.
Thank you, Your Honor. May I be
Thank you.
excused?
You're welcome.
Happy Black History.
The courtroom atmosphere was thick with anticipation as Alexander Oiedo, a man in a wheelchair, appeared before Judge Stephanie Boyd. He was there to plead guilty to unlawful possession of a firearm by a felon, a third-degree felony. With his attorney by his side, Oiedo meticulously went through the standard plea procedures, acknowledging his rights, the charges against him, and the specifics of the plea bargain. The agreement was clear: a cap of 6 years in prison, with the state remaining silent on his application for deferred adjudication, a form of probation that could eventually lead to a dismissal of charges. A second related family violence case was also being taken into consideration. As the proceedings unfolded, Judge Boyd meticulously reviewed the stipulated evidence, including the police report. She noted a crucial detail. The report suggested the shooting might have been accidental, stemming from an altercation. However, her focus sharpened on the fundamental violation. She addressed Oiedo directly, her tone shifting from procedural to personal. "What I can tell you is I'm not going to grant your application for deferred adjudication," she stated, her voice firm and unwavering. "Because you're here as a felon in possession of a weapon, which means you should know that you shouldn't possess a weapon." In that moment, she destroyed his best chance at a clean record, denying the deferred adjudication he had hoped for. While she denied his deferred application, she didn't impose the maximum prison sentence. Instead, Judge Boyd found him guilty and then delivered a powerful compromise. She sentenced him to 6 years in prison, but immediately suspended that sentence, placing him on community supervision, essentially strict probation, for 8 years. The conditions were rigorous: regular reporting, random drug testing, no contact with the witness from the related case, 100 hours of community service, GPS ankle monitoring for at least 3 months, and completion of anger management and MRT programs. The message was clear: accountability is non-negotiable. Oiedo, who thought he might walk away with a deferred program, now faces 8 years of intense scrutiny, a stark reminder that even one mistake as a felon can lead to devastating and lasting consequences.